Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. And now my first question is answered. Is the mic live? Kind of have to lean over. Thank you very much for being here. This is an incredibly special time for us. This is a real case, a real oral argument. If we weren't in Denison, we would be doing this in Des Moines at the Judicial Branch Building. So it provides an opportunity for people in the state of Iowa to watch what we do. So we welcome you and we appreciate taking time out of your lives to come and watch us. Tonight we have the case of State of Iowa versus Baraki. And are the parties ready to proceed? Thank you. State, you may begin.
May it please the court, counsel. Officer Sherrill did nothing wrong. He had no other options. In Iowa, when advising about the implied consent advisory, this court has handed down a reasonableness standard, whether the officer acted reasonably under the circumstances facing the officer, such that it would reasonably convey the implied consent advisory.
Excuse me, Mr. Miller, you said that the officer had no other option. Could he have obtained a search warrant?
He could have, Your Honor, and I was quoting the district court's decision, in fact, finding in this case in terms of his reasonable conduct at issue in this case. But you are correct that the officer could have gotten a search warrant to withdraw the defendant's blood or urine, practically speaking, forcing someone to I think, do a breathalyzer is a little trickier option. But that would have been a possibility in this case, yes.
While you're on that topic, I have a question. Why not wait another hour? There's 2 hours, and I think the significant action happened within 1 hour.
I think that the request was made after 45 minutes, Your Honor, but there was no indication that an interpreter would ever become available. The language line operator said that there was no interpreter available and did not know when one would become available. And it's not 100% clear, but I think on the phone call she says that there's not one scheduled. The officer then tries to use Google Translate, and there was no Tigrinian to English translation available. And he also gave the defendant what appeared to be the defendant's own phone to call whoever the defendant would like to call.
Would you agree with me that you would have a stronger argument if you'd been buttoned up against 2 hours?
I'm not sure that it's relevant. I think in the totality of the circumstances, was his conduct reasonable? So maybe it would be a slightly better argument, although I think that risking blowing the 2-hour deadline based on the exact timing of when you either do the PBT or effectuate your arrest is unnecessarily risky. And I agree with you, Your Honor, that it wasn't right up against it in this case.
But the 2 hours starts from when the officer utters it, will you take a test?
Right.
Right? So he can control the end of that 2 hours.
It's when you do the PBT, I believe, or you make your arrest.
Right. The 2 hours, I'm saying, once an officer asks.
Right, in the field, right, exactly. So you have to know exactly when you made your request, and you don't want to have your process of going through invoking it, let the defendant have an opportunity to run the clock out by not, cooperating or deliberating. At some point, you just have to invoke the statute and make your request. And, it maybe be a marginally stronger case if you waited another hour, but I don't think that in the totality of the circumstances here it was necessary.
Was there a passenger?
There was a passenger, Your Honor.
Did the passenger speak the language? Could they have translated?
That's not in the record, Your Honor. I think the closest thing is when the officer was speaking with the defendant, it sounded to me like when the defendant was trying to explain or answering the question where he was coming from, he mentioned that someone was new, and I think he was referencing his passenger, which suggests that perhaps he was new to the United States and thus unlikely to speak English. But the officer did give the defendant his own phone. At least it appeared to be the same phone that he had put in the bag when they were going through the intake process at the jail. He gives him the same red phone to make calls before the refusal's actually done. And so the defendant could have called anyone he wanted at that point and gotten someone to translate for him if someone had been
Isn't that assuming he knew that he could have done that? I mean, even that communication would involve communication.
The officer said he could call anyone, and the
In
defendant
English.
asked.
He said that in English.
That's true, Your Honor. And the defendant asked, like a friend, and the officer said, yes, anyone. So the defendant at least knew he could call friends. And if he had a friend who could speak English and Tigrinya sufficiently to, interpret, he could have brought that person there.
Is it relevant that he had, the same driver had an OWI a year or so earlier and went all the way through a deferred judgment, so should have been familiar with the process?
I think that's right, Your Honor. The officer did know that he had, in fact, given a breathalyzer test because one of the officer's colleagues had said he had administered the breath test to this defendant before, and it was a 2002 conviction, or deferred judgment, you're right. And also, the law presumes that every Iowan knows the law. That's 701.6. So it is presumed that the defendant both knew that he impliedly consented by driving, as well as that he had the right to revoke his consent.
In your view, what is the purpose of the informed consent advisory?
So, Your Honor, this court has said that the purpose is to allow people to make an informed decision. I think that the genesis of that was in Voss, and there's not any particular discussion of that in Voss. It's just stated that that's the case, the statute.
Well, if that is the purpose of the advisory, and there, as I understand, there's no contention here he did understand, at least on this record.
Correct.
If he doesn't understand the language, how can we say that it's informed unless we're just using it as a legal fiction and saying as long as the officer recites the right words, then it really doesn't matter whether anything was communicated?
Well, I think, Your Honor, we are using in this statute shall advise as a legal term. And it of course does, cases that have interpreted it in other states have said that it means communicate knowledge or make acquainted. I don't know that exactly solves the question, but here the question is, in all of the circumstances, was it reasonable? And that includes both the 2-hour limit as well as the main purpose of implied consent, which is actually in the statute of convicting drunk drivers to end the Holocaust or reduce the Holocaust on Iowa's highways.
Counsel, but you keep saying that the conduct is reasonable, but reasonable to what? Isn't it supposed to be reasonable to convey? And how is speaking English, and especially reading it as fast as the officer did, knowing that the defendant did not understand what he was saying, how can that be said to be reasonable to convey that?
The language is would reasonably convey. And of course, if the efforts had succeeded, they would have conveyed the information. So the attempts, I think, are what needs to be reasonable, and if they would succeed.
Okay, so how is it reasonable to continue to speak English to someone who you know is not understanding you?
I mean, at some point you have no choice, at least if you're going to go with the implied consent statute, to read it and tell the person that they need to decide whether they're going to rescind their consent.
I mean, how many people who speak English actually understand the implied consent advisory? That's why they're given the opportunity to consult a lawyer, right?
I don't know that that's the specific reason, but certainly they're allowed to make a phone call, yes, under the statute. And the defendant here was allowed to do so. And I think that your question kind of hits on another point, which is the legislature knew people weren't necessarily actually going to understand the advisory here. They're presumptively, if not actually, intoxicated. You have, drunk people or people high on drugs who aren't understanding things as well as they might when they're sober.
Counsel, here did the police officer need to actually try the translation line or try the Google app at all? Could he have just said, I don't know this language, I don't think we have a translator, I'm just going to read it to you in English? Would that have been enough?
I don't think that that would be reasonable under the circumstances. I think you have to make an attempt, and I think that that would be more consistent just reading it in English with decisions from other courts who have not said that the purpose of their advisory statute is to inform the defendant, but rather is to garner actual consent so you can convict people consistent with the purpose of the OWI statute.
But didn't we reject other statute or other states' constructions in Garcia? And so do we need to overrule or amend Garcia to be able to rule in your favor?
No, Your Honor. I think if you apply, and if the district court had faithfully applied Garcia, this is sufficient. I think, in fact, you would have to amend Garcia to rule for the defendant. You would have to change Garcia to say that you actually have to advise someone in a language that they understand. That is what New Jersey ruled in Marquez. That's the only state that I know to have done so. They did so in a criminal prosecution for revoking contempt or for revoking consent there, so it's a different context, being a criminal prosecution as opposed to here a administrative procedure. And here, of course, it was the criminal process that he went down where he was impliedly consenting. And we know that that's lawful, the regime, because a search incident to arrest is lawful because of the dissipation of alcohol from the blood, and that you have 2 hours. And so the officer could have just demanded that he blow into the machine under the search incident to arrest exception to the warrant requirement. And if he refused to do so, attempted to prosecute for interference with official acts, for example. And I'm not sure that that's a better regime for non-English speaking defendants than having officers try their best, make reasonable efforts to inform defendants of the right to revoke their consent.
How about maybe a situation that could back up even further administratively? You know the rules better than I do, they've changed quite a bit. But is there anything in the rules when a person, regardless of the language you speak, wants to have an Iowa driver's license and agrees to certain conditions, could there perhaps be a situation where that informed consent, implied consent is included at that stage of the game, that they understand it if down the road they're asked? Is that a situation in Iowa, or have our legislature not done that?
I am not sure exactly what is included in the materials for preparing for the driving test. I know that the DOT's website does have a truncated version of the implied consent regime and the ability to revoke consent. I also know that there's 21 languages in which the DOT's materials are offered in Iowa for the driver's test. None of those are Tigrinya. So, you know, you're also allowed to take the test using an interpreter if the test isn't given in the language that you speak. But this court in Garcia did say that interpreters aren't necessary, and it also said that the impossible or the impracticable is not required of officers.
Counsel, could you go back and repeat your point about the search incident to arrest? You were proposing an alternative regime.
Yeah,
so what were you saying?
So the search incident to arrest exception allows a breath test when a person the state has probable cause to believe that a person's driving under the influence. And so you could demand that they blow. The reason that the consent is necessary is because collecting a sample from someone who isn't cooperating is quite difficult. But the exception to the warrant requirement allows the search. So you could demand that they blow, and then if they refuse, you could attempt to prosecute under a statute that would make that a criminal act. For example, interference with official acts as a
Right, and I agree that's a potentially constitutional regime under the United States Supreme Court's decision in Birchfield, and then our subsequent case that overruled Pettijohn. I agree with that, but that isn't what our legislature adopted. They have an implied consent advisory, and it says that the motorist shall be advised, right?
I agree if you're going to go down the route of implied consent, that's true, but you can get a warrant without invoking implied consent, and there's no obvious reason that you couldn't use a different exception to the warrant requirement. The implied consent regime is basically creating a consent exception in the case by getting consent from the driver, but you could use the search incident to arrest exception, not use consent at all because the person there's probable cause to believe the driver's intoxicated.
Okay, so you're talking about exceptions to the warrant requirement for constitutional purposes, but what do we do about, as Justice Mansell points out, the fact that the legislature imposed the statutory requirement?
I don't think that in that regime you're invoking implied consent at all. You're not telling a person that if they don't blow, they'll lose their license for a year, and if they do blow, the penalties for OWI. You're just conducting a search like you would in any other case.
Right, no, I understand that.
So I guess I'm saying I don't think that the statute limits the state's ability to use a different warrant exception, and it obliges them to use.
So you're talking about the remedy. Maybe the remedy is not necessarily exclusion?
Well, I do think that it is odd to exclude evidence when the officers did nothing wrong. The state didn't raise that below, but no, I don't really think it's a remedy issue. I think that just legally speaking, there's no need to use implied consent at all. It's a statute and an avenue that exists, but you could go a different route, like a warrant or a search incident to arrest in which you ask the person to blow, and if they don't, because it's, I think, somewhat mechanically difficult to force a person to blow into a tube, and I think forcibly extracting urine would be perhaps problematic under Birchfield. You'd have to then prosecute them for that.
Does it matter in this case that the defendant did actually blow as opposed to refuse to blow?
I think so. I think he did, in fact, consent to the test. He impliedly consented, and then he actually consented by blowing because the officer's advisory was sufficient under the statute and under this court's decision in Garcia. And if the district court had applied Garcia and focused on the reasonable efforts of the officer and whether they would have reasonably conveyed the advisory instead of on the defendant's subjective understanding and subjective inability to understand, then it would have denied the motion to suppress. And so the state of Iowa is asking that this court reverse and order the district court to deny the motion to suppress. Thank you.
Thank you. Ms. Reddy?
May it please the court. Counsel. I am Vidhya Reddy. I'm here on behalf of Mr. Baraki. And Mr. Baraki would request that this court affirm the district court's determination that the data master breath result was required to be suppressed in the present case. In Garcia, this court established the standard that would apply in determining whether a driver's consent to chemical testing was voluntary and valid.
Counsel, in this opinion from the district court, I don't think that Garcia is cited at all. Isn't that a problem?
I don't think it's a problem. It is discussed in the underlying, I believe the prosecutor brings it up in their brief. It is, argued there. But I think the ultimate question is, did the district court apply the correct determination when it concluded that the result could not have been voluntary because under the circumstances it was obvious that this individual would not be able to comprehend.
Ms. Reddy, I don't think it's so obvious. At the very beginning, when the second officer approaches the car, and one of the first things he says is, "Will you get out of the car?" And the officer hardly gets it out of his mouth. And Mr. Baraki immediately unbuckles his seatbelt and starts to get out. So to me, when I watched the video, it's pretty clear. There's a level of understanding. My question to you is, if they have to really truly understand it, then aren't we giving a pass to anybody with a learning disability, for example, or perhaps anyone who speaks a different language, that if you don't truly understand it, because I would think a lot of people in our audience today, sober, if they were read the implied consent, especially at the rate it can be read, it's difficult to comprehend. Do we truly demand that they understand it and take a test over it?
We don't demand that they subjectively understand, at least under the Garcia standard. It is an objective, reasonable person test, but that doesn't mean that you don't take into consideration characteristics of the defendant that would be apparent to the officer during the interaction. And I think that's really where the distinction comes between having to delve into an individual's subjective understanding and inquiring whether, under the circumstances, we can conclude that the advisory was reasonably conveyed.
2 times the officer sneezed, and Baraki's response was blushing. Doesn't that tell you there's a level of understanding of not only the language, but our culture?
Well, I think the district court concludes that there is some very limited English speaking. I mean, I think in the ruling, the court says he speaks very little English. But the question is whether he had the capability to understand the advisory in the manner that it was conveyed.
Then I get back to the learning disabilities situation. What about that?
Well, I think if it's a circumstance where, for example, the officer is objectively aware of those limitations by the individual that is driving, then yes, the officer has an obligation to undertake some effort to convey it in a way that would be understandable.
Ms. Reddy, I want to ask you, what more should the officer have done in this situation? What should the officer have done that would have satisfied you?
I think the focus has to be on the measures that law enforcement institutionally can undertake to prepare for this type of circumstance when we're dealing with a non-English speaker. Some of the other courts, including the Wisconsin court that we followed in Garcia, talks about some of those, including having materials prepared in other languages.
How many languages, counsel? I mean, how many languages would the police have to be prepared to translate that advisory into to satisfy?
Sure. I'm not precisely sure. Certainly there are a large number of languages of individuals that, we could expect to encounter in Iowa. What I would point out is, as has already...
Isn't there a right to have it read aloud?
I suppose statutorily it is. And I guess...
So, how is the officer supposed to read it aloud in Tigrinya or a language that, they're not familiar with?
Well, there's a possibility that law enforcement can obtain oral translation in either audio or video form and have those prepared. The second...
Earlier you answered kind of generally what law enforcement could do. What could this officer in this particular case have done under these circumstances that wasn't done?
I don't think it's an answer to say that this officer, couldn't get someone on the line. I think it is appropriate when we're looking at reasonableness, objective reasonableness, that we look at what institutional...
My question is, in this particular case, under these facts, at this time of day, given what the officer did, what specific things could he have done that would have satisfied the advisory interview?
I would acknowledge that he had limited options, as the district court concluded.
So you're asking for a pass on all cases like this?
I'm saying that the law enforcement has to comply with the statute and with voluntariness
But in
standards.
this case, as Justice McDonald said,
In this case?
it would be a pass because you couldn't even come up with something this cop could have done different.
Well, I guess I wouldn't characterize it as a pass. I think certainly if they can't convey the implied consent advisory, then they can't obtain a chemical test.
Just as a very practical matter, this officer has a 2-hour window to figure out what to do, correct?
Correct.
And this case has been pending for months. And it's a very simple question. In the months that have passed since this 2-hour window closed, what else should this officer have done? And I think your answer is you don't know. And if you don't know, how is he supposed to know?
I think it's problematic to focus on the behavior of the individual officer in that circumstance and ignore the reality that
But
law
we're
enforcement...
deciding this case. We're not deciding a hypothetical case about institutional compliance. We're deciding in this case, was the officer's conduct reasonable? And I want to know what the alternative pathway was.
I think that's an incorrect, or I would disagree with that understanding of what the reasonableness standard is. I don't think we can say that...
This is what we said in Garcia. We said the determination is based on law enforcement, whether the law enforcement officer reasonably conveyed the consent warnings and is based on objective conduct of the officer rather than the comprehension of the driver.
That's correct,
So
but...
we're looking at the officer's conduct.
Yes, but he has to reasonably convey it. And the distinction between objective and subjective is the reality that we're looking at the entirety of the totality of the circumstances from the perspective of the officer. So for example, the officer is not expected to delve into the subjective understanding of a defendant who seems to understand or who seems not to have it.
But we also...
Is the district court's conclusion in the ruling that the officer, quote, did nothing wrong, close quote, isn't that fatal to the ruling? Doesn't that require us to reverse?
No, I don't think so. First, I would point out that even though that language is in there, I think that's an acknowledgement of the limited options this officer had given the absence of these other measures that have been taken or advocated for in other jurisdictions about having pre-prepared documents or audio translations. But number two, the court does ultimately conclude that the officer did do something wrong, which is collect a sample without valid voluntary consent, which requires that informed consent be provided first.
So Counsel, the officer calls this translation line that I assume is a law enforcement hotline of sorts. Is that right?
That's my understanding, correct?
Is it the officer's fault that hotline doesn't have enough translators to translate for this particular person?
It's not the individual officer's fault, no.
Let's talk about the institution then, Counsel. Was there anything in the record to show that there was a translator anywhere available? Any phone call that could have brought a Tigrinian translator at this hour? The record doesn't show that, does it?
The record doesn't no, the record does not show whether there was a translator that could have been obtained, for example, within the 2 hours. It does show that the officer had previously encountered an individual, right, that spoke this language. And at minimum, what that would seem to suggest is that would have alerted law enforcement generally of the need for
I have
servicing.
another, I'm going back to where I was before. This case seems obvious because the guy spoke a different language. There was obvious difficulty communicating. What about a case where a person's on an IEP and might look just like anyone else and speak perfectly clean, understandable English, but has no ability to understand something like our implied consent? Are you asking our officers on a case-by-case basis to decide whether or not they can read this implied consent, or are you asking for a pass for people that cannot understand?
I see that I am.
Oh, that's just yellow.
Oh, I'm sorry. Yes.
You got time.
I do have time. Great. I'm not sure whether objective reasonableness requires taking into consideration these other considerations. Possibly. I don't think in every case, I think it's clear in every case that the need for further efforts is evaluated from the perspective of the officer. So, for example, if there's no indication that there is some special need for accommodation under the circumstances.
Oh, isn't that walking a fine line? You can't tell somebody has a special need, and are they treated differently?
Yeah, I understand, but I do think that's the standard that has been adopted in Garcia and under Piddington. In fact, that's really where some of these other cases that we've cited that have also adopted a reasonable, an objective reasonableness standard say that they depart from New Jersey because of the fact that they don't require law enforcement officers to affirmatively delve into the language of preference or automatically provide that. It's whether they can, without an interpreter or a translator, whether it's possible to convey that information to the non-English speaker.
I want to shift gears a little bit. This was raised, I think, a little bit in the state's argument. We've talked about what the officer could or couldn't have done. Isn't it fair to say that your client, when they were handed their cell phone and told you can call anybody, they could have called a friend or someone who would have been able to translate for them?
Sure, absolutely, and he tried to and was not able to reach someone.
Well, he tried for very briefly, if at all, based on my impression of the video. It was less than 2 minutes, and it's not clear how much he was dialing or just looking at his phone during that time, isn't it?
I think it's pretty clear he dials and tries to reach someone and then gives the phone back to the officer. The officer had initially confiscated the phone, and at that point, you know, the defendant had given it back to him after trying to make a call. Certainly, I suppose, you know, the officer could have offered him the phone again later during this 2-hour period. The officer could have tried to, again, call the language line. There could have been other options available beyond.
But you would agree that under 804.20, normally the defendant's right is only to call a family member or an attorney, not to call anybody, right?
Yes, but I guess I would suggest that the way that was conveyed to the defendant, I mean, it would certainly satisfy that statute, and perhaps you're right. I mean, perhaps, you know, he was calling a friend rather than a family member. We don't know. We don't know that it was broader than what the statute allows. But ultimately, under the implied consent statute, it's the state's burden to establish that they have undertaken the measures necessary to reasonably convey the implied consent advisory.
Your client.
I'm sorry, let me just finish one more. Can I? She's the chief, so normally she does first.
He's older than me. He gets to go first.
I mean, but could we view the fact that the officer gave your client his cell phone back and said you can call anybody, that's an additional measure that the officer took?
Oh, absolutely,
the
yeah.
officer, in a sense, went above and beyond what the statute actually required in terms of what 804.20 requires.
Well, I think absolutely the officer gets credit for providing that opportunity in an effort to, find a reasonable way to convey this information. But the problem is that's not all that's required. It's not just the officer take good faith, efforts that are trying to meet the standard. They also have to actually reasonably convey this information. And
I get back to that IEP. That's such a subjective test. There's no way in the world our officers out there pulling people over for potential drunk driving cases can make an analytical assessment as to whether or not they understand. Like I said, I feel like what you're asking for is somebody who, if the state can't prove they understood, the driver gets a pass.
we're not. We're absolutely not.
Well, you're not telling me anything to convince me that what the officer did falls short. You even have said he's done everything. What else, pray tell, could he do other than let him go?
It's not enough that the officer did everything he could in that circumstance. The question is, did what he did actually reasonably convey the information? That is the standard that we've adopted in Garcia, and that is the voluntariness standard that applies to this case. If there are no other questions, I will thank you all.
Thank you. Mr. Miller.
I'd like to make 2 points. First, this court has said that reasonable efforts do not mean an officer needs to take extraordinary or even impractical efforts. Defense counsel, as Justice McDonald pointed out, had over a year to come up with some practical thing the officer could have done differently. And as the district court found, there was nothing else he could do. Under Garcia, the district court erred and this court should reverse. The second point that I'd like to make is I'd ask this court to particularly focus on Funes from Maryland High Court. And there, they rejected Marquez, which I think is essentially what the defense is asking this court to do, which is add a in-your-language requirement. And they explicitly rejected it, in part because doing so would give people a pass who spoke obscure or uncommon languages. And that is not a holding this court should reach. If the district court had applied Garcia, it would have denied the motion to suppress. The state asked that this court reverse and order the district court to deny
You
that
said
motion.
nothing else the officer could have done. I think that's a bit broad. I think I can think of a few things they could have done. The question is whether that's reasonable. We get back to the warrant, especially in Sioux City, big city, lots of judges, lots of DAJs, and we have something now called remote, where they are able to do electronically warrants. And you still had a whole hour. Isn't that something that could have been done?
I agree with you. If we'd gotten a warrant, this wouldn't be an implied consent case, but the question is, could have done to reasonably convey the implied consent advisory. So using the implied consent in Garcia, there was nothing else the officer could have done. But you're right, Your Honor, he could have tried to get a warrant, probably okay under Hitchens until the person refuses. So he could have gone that route if he had wanted, although this court has acknowledged that warrants in the OWI context don't add any particular benefits in terms of protecting civil liberties, and they're also somewhat impractical across Iowa. This occurred, between 12 and 1 o'clock at night.
Counsel, should we look only at the officer or at the state sort of more generally for efforts here? So let's say that translation hotline wasn't staffed. Would that matter here? So the officer makes a reasonable effort to place a phone call, but the state drops the ball in staffing the hotline.
So I think the hotline is a national hotline as near as I can tell, because other states that have cases like this also use the language line. But in any event, I think that the standard of published materials by the state is on a statewide basis, but you're actually analyzing the officer's conduct. So how reasonable is it for the state of Iowa to publish a material or a video in Spanish as compared to Tigrinya could be a factor you would consider in a case like this. And it's a thing that other courts have acknowledged in common languages. It might be more reasonable to have a recorded video or a printed form. Of course, not every state, or I guess, I don't know, I assume not every state requires it.
Earlier, you told me that reasonable efforts were done here because he made the hotline phone call and he tried the Google app.
Yeah.
Well, if the hotline phone call is really meaningless, right? Like, let's say he knows it's not even staffed, that no one's gonna answer it. How is that reasonable?
Well, I think that the defendant could have cross-examined on that point if he thought that the hotline was insufficient or somehow, a pretext. I think that we do analyze efforts the officer took. And of course, as I said, the defendant could have pointed out any problems with the language line. And this is in the defendant's motion below, but he did say that he had an interpreted OWI before. I'm assuming that was via the language line, but maybe it wasn't. Maybe there was someone there. But again, the officer went above and beyond the requirement for a phone call, letting the defendant call anyone, not just the statutory limit.
You know the administrative rules better than I do. Is there anything in Iowa's administrative rules, I guess, or statute, when a person gets a license, that there is a discussion about implied consent?
I don't know that, Your Honor. I'm sorry. I'm not sure.
On the warrant option, I'm somewhat intrigued by that. I don't honestly know this answer. Under 321J, the officer can bypass implied consent and just go straight for a warrant with a driver who is copacetic, not someone who's unconscious or in another situation. Is that true?
I think that the relevant case from your court, I think, is Hitchens. And it says that after there's a refusal, or perhaps the invocation of implied consent by the officer to make the request, then audibling to the warrant is unlawful. But I'm not aware of a case that says that you're in, the room and you're next to the machine and you're starting down the path, but you haven't actually made your request yet that would prevent a warrant. So I'd say it's an open question, but at least possible.
Because here's what occurs to me, that the defendant, in a sense, has a right to refuse the test and accept the suspension,
Yes.
but then avoid the evidence that might be generated by providing the test, that you, in a sense, deprive the defendant of that right when you go and obtain a warrant, right?
If you've invoked implied consent, this court has said you cannot get a warrant for basically the reason that you said, Your Honor. But it has also said that the warrant provision of the OWI law didn't repeal 808, the general warrant statute, and blessed getting warrants generally to investigate drunk driving, although it is not always practical to do so, given the dissipation of alcohol evidence, as well as the availability of judicial officers in rural Iowa at late hours of the night. And so the state would ask that this court reverse the district court and order it to deny the motion to suppress. Thank you.
Thank you. Case of State versus Baraki is hereby submitted.